In the case of Joseph Stephen versus Santhana Swamy, all the original accused were charged and tried for certain offences. Feeling aggrieved and dissatisfied with the judgment and order passed by the High Court, reversing the acquittal and thereupon convicting the accused, while exercising the revisional jurisdiction under Section 401 CRPC, the original accused have preferred appeal. S. Nagamuthu, the learned senior advocate appearing on behalf of the accused, submitted that the High Court has erred in reversing the acquittal and convicting the accused. He relied upon Section 401, subsection 3 of CRPC. While exercising the revisional jurisdiction, the High Court has no jurisdiction at all to convert an acquittal into conviction. The only course open to the High Court is to give its own finding and remit the matter either to the trial court or the first appellate court. He relied upon 4 cases to support his submission. The first one is K. Chinnaswamy Reddy versus State of Andhra Pradesh. The second one is Sheetal Prasad versus Srikanth. Third one is Ganesh versus Sharnappa. And fourth one is Rambrich Singh versus Ambika Yadav. He further submitted that by Act 5 of 2009, proviso to Section 372 CRPC was inserted by the way of an amendment where the victim shall have the right to prefer an appeal against any order passed by the court for acquitting the accused. Therefore, once the victim has a statutory right of appeal against the order of acquittal under Section 372 CRPC, the revision application before the High Court shall not be entertained against a judgment and order of acquittal. He relied upon Section 401, subsection 4 of CRPC, and also the case of Kodagalli versus State of Karnataka to support the submissions. Also, while preferring an appeal under Section 378, subsection 4 of CRPC, the victim has absolute right over the appeal and he is not even required to seek leave as required in case of a complainant. The first appellate court gave convincing reasons while acquitting the accused and recording the findings in favor of the accused, which were not required to be interfered by the High Court in exercise of the revisional jurisdiction. Dr. Joseph Aristotle, the learned advocate appearing on behalf of the respondent state, agreed to the submissions made by the senior advocate appearing on behalf of the accused. However, he argued that the High Court could have treated the application for revision as a petition of appeal provided under subsection 5 of Section 401 of CRPC. In rejoinder, S. Nagamuthu opposed it and replied that in order to treat the application for revision as a petition for appeal, firstly, the High Court has to pass a judicial order, and thereafter the High Court is required to give an opportunity to the accused as if the High Court is deciding the appeal against the order of acquittal. While considering the revisional application, the revisional court would have a limited scope. However, while deciding the appeal, the appellate court has a wider jurisdiction than that of the revisional jurisdiction. On hearing both the sides of the case, the court considered the following issues. The first one is whether the High Court, in exercising the revisional jurisdiction under Section 401 CRPC, is justified in convicting the accused by converting the acquittal into conviction. The second one is, in a case where the victim has a right of appeal against the order of acquittal, as provided under Section 372 CRPC, and the victim has not availed such a remedy and has not preferred the appeal, whether the revision application is required to be entertained at the instance of the party or the victim of preferring an appeal. The third one is, while exercising the powers under subsection 5 of Section 401 CRPC, treating the revisional application as petition of appeal, whether the High Court is required to pass a judicial order. In the first issue, the court referred to the case of K. Chinnaswamy Reddy versus State of Andhra Pradesh. If the order of acquittal has been passed by the trial court, the High Court may remit the matter to the trial court and even direct retrial. However, if the order of acquittal is passed by the first appellate court, in that case, the High Court has two options available. The first one is to remit the matter to the first appellate court to rehear the appeal. The second one is to remit the matter to the trial court for retrial. Therefore, in the present case, the High Court has erred in cautioning and setting aside the order of acquittal and converting an acquittal into the conviction and consequently convicted the accused while exercising the powers under Section 401 CRPC. And so far as the second issue is concerned, the court referred to the case of Mallika Arjun Kodagalli. The right provided to the victim to prefer an appeal against the order of acquittal is an absolute right. The victim has not to pray for grant of special leave to appeal, as the victim has a statutory right of appeal under Section 372 proviso. And this section does not stipulate any condition of obtaining special leave to appeal like section 378 subsection 4 of CRPC. And as far as the third issue is concerned, the High Court has to pass a judicial order to treat the application for revision as petition of appeal. Subsection 5 of section 401 CRPC provides that if the High Court is satisfied that such revision application was made under the erroneous belief that no appeal lies thereto and that it is necessary in the interest of justice to do so. Therefore, the court finds it fit and proper to remit the matter to the High Court and to treat the revision application as petitions of appeal under section 372 CRPC, as the appellate court would have a wider scope and jurisdiction rather than the revisional court.
Today, this case for discussion is Joseph Stephen versus and others versus Santhana, Samy and others. This is a case filed before the Honorable Supreme Court of India under criminal appellate jurisdiction, and the case was decided by judges Justice M.R. Shah and Justice Sanjeev Khanna. Coming to the facts of this case, the petitioners in the of the case were the original accused under the offences offences punishable under section 147, 148, 326, 324, 307, 506 clause 2, read with section 149 of IPC. And these sections deals with rioting with armed weapons, voluntarily causing hurt, voluntarily causing grievous hurt, attempt to murder, unlawful assembly with common object and all. And this case came to the trial court of Chief Judicial Magistrate of Tiruchirappalli, and the trial court by an order judgment in 2012 convicted the accused for the above sections except 307 and 506, that is attempt to murder and criminal intimidation, and thereby acquitted the accused. Feeling dissatisfied with the judgment of the trial court, the accused persons preferred an appeal before the additional sections judge, and the appellate court allowed the appeal and acquitted the accused. The victim agreed by the order of the appellate court approached the High Court of Judicature Madras Madurai bench as a private respondent through criminal revision petition under section 397 and 401 of CRPC. While this case came to before the High Court, the court, by exercising its revisional jurisdiction, allowed the appeal and convicted accused persons for offences other than the offences under section 307 and 506 clause 2 of IPC, and restored the judgment and order of conviction and sentence by the trial court. And the High Court also modified the sentences imposed by the trial court, agreed by the order of the High Court by reversing the judgment of the appellate court. The accused persons appeared before the Honorable Supreme Court, challenging the order of the High Court. Now, when this case came before the Supreme Court, the counsel for the accused submitted before the Supreme Court by citing certain case laws like Chinnasamy Reddy versus State of Andhra Pradesh, Sheetal Prasad versus Srikanth, Ganesha case, etc., and submitted that as per section 401 clause 3 of CRPC, while exercising the revisional jurisdiction under section 401, the High Court has no jurisdiction at all to convert the acquittal into one of conviction, and the High Court can only give its own findings, and thereafter either they can remit the matter back to the trial court or to the first trial court, appellate court. And the counsel for the petitioner also submitted that as per the amendment of section 372 CRPC in 2009, the victims have the right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation. And this is a statutory right. And this statutory right of the victim has been recognized by the Supreme Court in Mallikarjun Kodagai versus State of Karnataka, that is a 2009 judgment. As per that judgment, the Supreme Court held that the victim has absolute right of appeal and he is not needed to seek leave of appeal, as in the case of section 378 clause 4 of CRPC. And while considering they also submitted that by even the Supreme High Court considers revision petition as appeal by exercising the power under section 401 clause 5 of CRPC, the High Court is needed to pass a judicial order stating the reason for considering the revision petition as appeal appeal as appeal. Now, when the defense, that is the respondent state here and held that the revision petition is treated as appeal in this case and is dealt accordingly. And they also held submitted that the victim has the right to appeal under section 372 and it cannot be taken away. Hearing the submissions of both sides and considering the facts of the case, the Supreme Court framed the issues. And the first issue framed by the Supreme Court in this case is whether the High Court, in exercise of revisional jurisdiction under Section 401 CRPC, is justified in setting aside the order of acquittal to an order of conviction. Similarly, when the victim who has the right to appeal under Section 372 CRPC, which was not availed, whether the High Court has the right to have the power to consider revision petition as appeal at the instance of the party, whether the High Court should pass a judicial order under Section 400 Clause 5 in such a circumstances. These were the issues considered. When the Supreme Court considered the decision for this case, the Supreme Court considered the judgment of Chinnasamy Reddy case. Here, the Supreme Court considered two situations. That is, if the trial court passed the order of acquittal in the first instance, and then the High Court has the power. Then, in such a circumstances, the High Court has the power to interfere with the order of acquittal in revision. In such situation, the order of acquittal has to be set aside and sent back to the trial court for retrial. And if the trial court has convicted the accused in the second situation, then the appellate court has acquitted him. In such a case, the order of appeal court should be set aside, and the High Court can either ask the appellate court to rehear the appeal or can send the case back to retrial to the trial court. And this is on the discretion of the court and based on the facts of the case. Here, in Supreme Court pointed the case of Sheetal Prasad. Here, in that case, the court held that under Section 401 Clause 3 of CRPC, it prohibits the conversion of finding of acquittal and into a conviction, and in such cases, retrial or reversing must be ordered. Rehearing must be ordered. Similarly, in Ganesha's case was also cited by the Supreme Court, where Section 386 Clause A authorizes the appellate court to reverse an order of acquittal, find the accused guilty, and pass sentence on the person found guilty. But here the court held that, but under Section 401 Clause 3, the revision power does not authorize the High Court for doing the same, which was given in Section 386 Clause A. In case where the finding of an acquittal was given by misreading the evidence or non-considering of an evidence, then the High Court can set aside the order of acquittal at the instance of the informant and can direct the trial court for a fresh disposal by the considering the merit of the case. And while using such a provision, the Supreme Court is saying that the High Court should give abundant caution in that, so that the interference with the order of acquittal in revision is called only in cases where there is a manifest error of law or procedure, and in those exceptional cases in which it is found that the order of acquittal suffers from glaring illegality resulting into miscarriage of justice, so that it has to be used with caution. The High Court can also interfere in those cases of acquittal caused by shutting of the evidence, by which should have been considered in the normal course, or where the material evidence has been overlooked. Similarly, the Supreme Court also considered Bindeshwari Prasad Singh versus State of Bihar, which is a 2002 judgment, where the Section 401 shall be deemed to authorize the High Court to convert a finding of acquittal to one of conviction. As in this case, the judgment was that it places a limitation on the states that it places a limitation on the powers of the revisional court, and if such an interference is prohibited or limited, then the High Court cannot do it indirectly by ordering retrial. Such retrials can be preferred only in exceptional cases where the interest of public justice to correct the manifest illegality or prevent gross miscarriage of justice. So the court considered the first issue and by upholding the judgment in Chinnasamy Reddy case, where by citing all this, that the High Court cannot convert the finding of acquittal to one of conviction. They can only remit the case back or order a retrial. Then, considering the second issue, the court that is whether appeal is not brought before the court, whether revision application can be entertained at the instance of the party. Here, this under section 401 clause 4, the court states that the court and under this court an appeal lies and no appeal is brought. If no appeal is brought, no proceeding by way of revision shall be entertained at the instance of the party who could have an appeal. So the Supreme Court held in this case that no revision shall be entertained at the instance of the victim against the order of acquittal in a case where no appeal is preferred and the victim is to be asked to file a new appeal. Now, with the third issue, that is with the passing of judicial order considering considering a revision petition as an appeal. Now, in this matter, the court held that as per section 401 clause 5 of CRPC, the High Court has to pass a judicial order because as per the subsection 5 of 401, if High Court is satisfied, such a revision was made under erroneous belief that no appeal lies or is necessary for the interest of justice, then the High Court has the power to convert a revision petition into appeal and take decision. But if such a decision is considered, the High Court has to consider, state the reason and record the situation as provided in the section. So the High Court has the jurisdiction to treat the application of revision as a petition of appeal with the same as that was under section 401 clause 5. So in this case, the High Court has quashed and set aside the order of High Court of High Court of Judicature of Madras and had remitted the case back to the court for reconsideration.